everyone. Thanks very much for joining us on this second part of the Family Office series of talks and webinars. Today we'll deal with Family Office privacy. Now, just before we get started, I'd like to just introduce panelists. Obviously, I'm Zach Lucas from Spencer West. Happy to be joined by Nancy Chin from Bedell Kristen in Jersey, who's head of their private client team there. Aki Korzoni Hussein, who's partner head of regulatory and tax at Harneys in Cyprus. John Shoemaker, who's US Counsel Butler Snow in Singapore. Steve Sokic at IQEQ Group Head, actually based in Jersey, not UK. Andrew Ho, Head of Private Wealth, IQEQ Singapore. And then from the cybersecurity side, which is different for us, we've got Paul Jackson, who's Head of Cybersecurity and Investigations at Kroll Hong Kong. And then we've got Jez Owen, who's Managing Director, Cyber Risk, based in Singapore for Kroll. So very grateful for everyone to be on this panel. It's a larger panel than we usually have. Just before we get started, I'll just do the usual admonitions when it comes to these forms of virtual roundtables. This is not meant to be legal advice, not to be relied upon as legal advice, and doesn't form a legal relationship with anybody on the panel. This is just effectively the honest views of the practitioners involved, and so shouldn't be relied for any other purpose than just broad guidance. I just need to say that at the beginning, just so that we are clear on the scope of the discussion that's ahead. Okay, I'll just run through the agenda for today. We'll start with just setting the scene of where we are with respect to the ongoing battle between privacy and transparency, and how all of this is transpiring in the context of the humble family office, the international family office. We'll then go on to consider the single family office and the assessment of all of the myriad regulatory impacts that this is now undergoing as a result of the various international initiatives, either from the FATF, the OECD, or from the European Union. We'll then take we'll look at the detail and we'll step back, and we'll look at the wealth planning implications of all of this and the impact this is likely to have to the industry at large, what we should be doing with respect to advising clients, and the best practices going forward. So I think it's an important aspect of this, because obviously a lot of you who are joining are in the wealth management industry, and you'll want to know what's the best practice that we can adopt going forward, given the amount of transparent related initiatives that are now rolling off. We'll end the webinar with a discussion that's not usual for us, but I think is extremely important in the context of single family offices, particularly deregulated single family offices, which is the cybersecurity risk and the infrastructure around how families can protect their privacy from hacking, from bad actors in the marketplace, and what's best practice. And I think Jez and obviously Paul will have things to say about that, which is good advice. If we have time, we'll have questions and answers. Now, at the end of this, if you've registered on this, then we'll circulate both the slides, the recording, and you'll also have access to the podcast version of this going forward. So all of that will be made available probably in a few days after the event. Okay, so privacy versus transparency. And what I'm going to try and do is just basically set the scene. Where are we right now, and how is this all transpiring? And I think the broad aspects here is obviously privacy and data security is quite important. We're seeing many countries adopting data protection acts, for instance, and trying to protect online security of your identity. And on the other side, we have greater emphasis on transparency going forward. So I think things that we ought to take into consideration going forward are the COVID-19 policy responses that we're likely to see tax administrators around the world adopting, the significant economic and fiscal impact that COVID-19 has had, as in is continuing to have, the rather restricted policy choices that jurisdictions will have. They can't do austerity because in many cases they're already in austerity, so that's not a choice. And where this all plays out when it comes to high net worth engagement strategy and what's informing that strategy going forward. I'll share a couple of the sort of pressure group issues that come up with what is the high net worth engagement strategy likely to be. So we have policy reports. They're published every year. Tax Justice Network publish a yearly policy report on the state of tax justice. And sometimes these are endorsed by institutions like the United Nations and their financial integrity and sustainability guidelines. Now, what do they say? Well, in the context of private wealth held internationally, this is what tax justice will say. They say roughly 171 billion in lost taxes per year are attributable to individuals, to private high net worth individuals. You might, have a look at this. It's free on the internet. You can get it and download it and read the methodology. You might not agree with it, but the context in which this is published, policymakers take it into consideration and they also take it very seriously. So it sets the scene of what they think is happening internationally and the steps that they need to take. That's quite a high figure, 171 billion per year. So as I say, you might take a look and say rightly or wrongly that figure is incorrect. We also have a constant stream now, yearly stream of data leaks and sensational data leaks showing structures that some are compliant, some are non-compliant, and it seems to be a recurring theme. We recently have the sort of Swiss papers recently came out, and this is an accelerator. But also in this context now, sadly, we also have this, which is the troubles that we're having in Ukraine. And I mention it not to be political in any way, but just to say that I think that this is going to be an enormous accelerator to many of the initiatives that were planned or were implemented in a sort of spot-specific way, with some jurisdictions doing it and some not doing it. I think that the problems here with the oligarchs and the targeting of private wealth for some of these oligarchs will likely see an accelerator to a lot of the initiatives that are currently in the pipeline but have not had the impetus. I think that that's going to be one of the net effects of the current crisis going on in the Ukraine. So that's setting the scene. Not particularly joyous, and it's pretty grim actually in terms of how the industry is being portrayed in terms of cross-border wealth and structuring them in a better way. So then that leads us to the sort of humble family office and how it's getting caught up in the crossfire of all of this stuff. And so the assessment that I'm going to go through will look at beneficial ownership registers. Where are we at with this? What's going on? How, is it companies, trusts, both, whatever assets? Then we'll look at some of the mandatory disclosure rules that have been previously published by the OECD and look particularly at opaque offshore structures and how that works. We'll look at economic substance rules. They're now a reality, and see some of how that works and some of the issues surrounding that. We'll look at the common reporting standard as it applies to family offices in particular. We'll also look at FATCA, again, as it applies to family offices. And then we'll wrap up with a look at real estate, because I think that's going to be an asset class that's going to be particularly targeted going forward for some of these transparent initiatives that are being rolled out. We'll look at US real estate first, and then we'll look at UK real estate. All of this in the context of investments held by a family office. Okay, so as always, we do a schematic to help illustrate the structures at hand. Here the schematic is a trust, a holding company, a fund management company, and a fund company. This is a classical Singapore single family office structure. So I'm using this as the basis. I haven't expanded the structure to show a purpose trust holding the sort of shares of a private trust company, etc. I think we'll stay with a basic format of trust, holding company, and then the fund management and fund company. Now for jurisdictions, I'm going to choose Jersey, BVI. So Jersey Trust, BVI Holdco, and then BVI Fund Company with a Singapore Fund Management Company. Again, a fairly typical structure for a lot of the high net worths that are using Singapore. Finally, the interested persons in the structure. So we have beneficiaries, we have a settlor, and then we have a protector or a power holder. So again, classical stuff if you're used to how these structures look on a piece of paper. Now, beneficial ownership registers is the first thing that we're going to discuss. And I'll probably invite Aki, if he could help us to just run through how these actually work. How does it work, a beneficial ownership register, particularly looking at it from the context of what's going on right now in places like the BVI. And we've got obviously a holdco and a fundco both of which are indicated as being in the BVI. So Aki, how do these things generally work at the moment?
Isaac, and thanks, and good afternoon, everybody. Pleasure to be speaking on this webinar. So, beneficial ownership registers, how do they work? Well, I think from an offshore perspective, it's fair to say we don't have lots of data to go off. These are new measures that are being introduced. What we're generally looking at as a guidance for this are, for example, countries like the UK and other and EU member states. And what we are seeing is that there are some discrepancies, but in the detail of these registers. But in broad terms, the registers work by effectively requiring each company or the directors on the companies to lodge information, typically with a corporate registrar, as to persons with significant interests, typically above 25% in the company. And so details would have to be lodged. Now, whether you get into the question of for example, with this structure here, as to whether the settlor or the protector or the beneficiaries need to be disclosed, again, we're seeing discrepancies looking at EU member states, but between the sort of data that needs to be disclosed. Some EU member states, for example, are saying that you only need to disclose the trust. So it's enough just to have the trust disclosed. So name of the trust. Others look through the trust to including data on beneficiaries, settlors, and protectors. I mean, on the whole, the registers, the AML rules on which the registers are based are starting to line up more closely with concepts within CRS as well. So where you can't identify someone, then it's usually that you need to identify someone that has some sort of material control over the arrangement, whoever that may be. So I think that's in a nutshell.
Right. And is it public at the moment from a BVI perspective?
No. So the public beneficial ownership registers have not been introduced yet in the BVI. Right.
Because we have what was touted as a sort of draft statutory instrument, effectively compelling the overseas territories to institute a publicly accessible beneficial ownership register. And then this is with respect to companies. And then there was this, sort of background, sort of political dealings. And then one by one, the overseas territories lined up and said, yes, they will go voluntarily without having it foisted onto them. Is that still the case? Are we still online for public access to beneficial ownership of companies into 2023? Is that still the case?
That continues to be the commitment date, the relevant commitment date. The last public announcement from the BVI on this was back in 2020, and again the Premier mentioned that the commitment would be that these registers would be implemented in 2023. Now we haven't had a recent update, so it's difficult to say. What's the state of play as at today on this? It's all being held, as you'd appreciate, quite closely to government.
Right. I mean, clearly, I don't know if you've been watching some of the political announcements, what Boris has been saying in the UK, but the sort of mad push that they've got now to push through legislation, he's making it clear that this will also, everything he's talking about will also apply to British overseas territories. So I think given the context of what's going on in Ukraine and the clampdown on the oligarchs, it's probably unlikely that the UK would relent on these registers actually being operational. I mean, is it possible that we could have these registers being foisted at a faster rate than 23, given the context?
The registers, I think, go to the heart of the constitutional relations between the overseas territories and the UK.
Yeah.
The overseas territories are internally have full internal self-governance guaranteed by their constitutional orders. So what that really means is that to the extent that it's an internal matter, and typically, company law is considered an internal matter for each territory. That's determined by the territory. But I think with the Ukraine crisis, that suddenly becomes a matter of, you could argue, foreign policy, and the UK actually is responsible for foreign policy, for sanctions rollout in the overseas territories directly. So it's a very interesting area to look at these two potential issues.
But they're probably not going to do it in the way in which targeted sanctions or a targeted register just for Russian-related beneficial owners. It will probably be a broad brush. The whole lot is open to public scrutiny and not just a targeted basis. That's probably right, isn't it?
That is correct. We haven't seen any restrictions on, as a matter of sanctions law yet, although the position is constantly evolving. We haven't seen any restrictions on Russians holding assets in companies. So, and I think, who knows what's going to happen. But this overseas territories order that you have up here is framed in the same way that as sanctions legislation when it's implemented in the overseas territories. It's an ordering council. It goes back to imperial legislation and all those sorts of things. So let's wait and see what happens.
Okay. Now, it's not just the overseas territories, but it's also the Crown dependencies. Nancy, from your perspective, you're in Jersey. How is this playing out in Jersey? Have we got preparations for this? Have we got any sort of draft legislation going? What does it look like from a Jersey, Channel Island perspective when it comes to this public access to corporate registers in Jersey?
Thank you very much, Zach. No, it's been interesting because I think insofar as the Channel Islands are concerned, they've always been the early adopters of these transparency measures. In particular, if you look at the history, CRS, FATCA, they were one of the early adopters when it comes to having a register for collating beneficial ownership information. They're also one of the early adopters, but it's a completely different question as to whether that information should become available in the public sector. So insofar as the Channel Island position is concerned, actually, I don't think a huge amount has been done since that public statement was made. And I think the statement from memory was made in a bit of a haste because obviously there was a lot of pressure from the UK in respect of the overseas territories to introduce a public register for companies. And the Channel Islands have always been very keen to preserve its autonomy. So I wanted to release a statement to say, look, we're supportive, but at the same time, our constitutional position is that for measures like this, we need to adopt our own laws. We're very happy to comply with the international standards, but until such time, we're not going to necessarily introduce our own laws off the back of our own initiative for things like this. So so far there hasn't been anything further in relation to this particular aspect. But having said that, I think the government has started to sort of implement the spirit of the public register. So for example, in January 2021, we introduced a new registry law. So whereby certain information in relation to companies will now be made available in the public. So in particular, the information about controlling persons, so directors of companies, will now be made available in the public. And that law also affects other incorporated entities. So in the private client space, if the clients use a foundation structure, the information about council members will also be caught by that new law. So information in relation to council members will now be made available on the public register as well.
Right. And there's the, in terms of the, go ahead, Steve, go ahead. Sorry, did you want to say something, Stephen? No? Okay, so in terms of the Channel Islands' assurance that they would follow through with these registers, they had this undertaking given, and it was Guernsey, Jersey, and Isle of Man back in June of 2019, given to the European Commission that they would follow through with this upon obviously the Commission reviewing the sort of aspects of the 5th Anti-Money Laundering Directive. Given the recent statements that we've had in the European from the European Commission, from Ursula, and from the European Parliament, particularly in light of Ukraine, it's probably near impossible that anything will change. If anything, things will ramp up in this area. So do you think that in terms of the timeline 2023, we're probably locked into that going forward, if not sooner, if things go terribly bad? I mean, what do you think, Nancy?
Yeah, I mean, I think that's a very valid point, you know, and also in Jersey, we've always been, in the Channel Islands, you know, we've always been very keen to ensure that we don't, well, our AML procedures are extremely robust. So, you know, insofar as this initiative of ensuring that the structures are transparent, we know exactly who the owners are, you know, that goes to the very heart of the policy intent that's always been adopted in relation to all these measures. Yes. So I think that, you know, if there is the political movement to expedite this process, I think that is very possible.
Yeah. And just to make it clear to everyone that's viewing this, when we say public access, we mean public access to the beneficial owners of the company. The beneficial owners might be through a trust. So it means effectively the controlling persons of the trust. There might be differences in the rules on what are the controlling persons of the trust. So if you had a Singapore trust sat on top of a sort of BVI company or a sort of Jersey company, you'd still have exposure, even though Singapore doesn't have this concept at the moment because it's not a global standard, right? Okay.
Sorry, Zach, can I just make a quick point on the Crown dependencies? Just in addition to what Nancy was mentioning, I think one important caveat or condition that the Crown dependencies did make in that statement, I think is important, which was sort of referring to a level playing field, i.e. if the rest of the world doesn't do it, they won't do it. So that was an important condition that they had in there. And I agree with Nancy, nothing's really changed since then, or nor have I seen any announcements in that respect. But I think that condition's an important one, and we'll see how that plays out. But I don't think we've seen much to suggest either way on that condition being filled or not filled.
Yeah, it just, the problem is we've got the whole Ukraine crisis, which is acting as an accelerator and an emotive issue in all of this now. Okay, trust registers. So with respect to Jersey, Channel Islands, any prospect of the trust registers that we're now seeing, obviously in the UK and the European Union, Nancy, from your perspective, any mutterings about this?
I think there has been quite a bit of pressure being put on the Channel Islands to introduce a trust register, but in particular from the UK. But certainly, I think the current position is that, you know, we don't see the need really to have a separate register for trusts, given all the other robust measures and laws that we have in relation to beneficial ownership, controlling persons, etc. In particular, that law I just mentioned. Yes. So at the moment, there's no desire and appetite to introduce a trust register. I mean, but having said that, you know, information in relation to trust, in relation to who the beneficial owners are, controlling persons are, certainly, you know, the service providers in Jersey have that information available. So it's just that when you have a central register, which is going to be made available in the public, is that something we have an appetite for? I don't think so. But then again, you know, so much of this comes down to the political pressure.
Yeah. Aki, from your perspective, looking at Cayman and BVI, because they have very significant trust industry. Bermuda as well actually has a significant presence in this as well. Have you seen anything from your side that would indicate pressure being brought to bear on trust registers there?
So we haven't really seen anything, certainly from a BVI perspective, on the trust register. So I think we're all the focus is on the company's register. And I think even with the trust register, again, the concept of a public trust register is, I think, quite quite far off in some ways. Again, the EU experience seems to be that there's potentially a mix, that there isn't a consensus that it has to be public. It can exist privately. So I think we're far off from that from an OT perspective.
Okay.
Yeah, just one more point to add, Zach. Sorry, I don't know whether we're coming on to this shortly, but just even though there's no register for trusts, given the new law that I just mentioned, which applies to companies, if a company acts as the trustee of a trust, then the trustee, the PTC information could be made available on the public register. So there, the controlling persons, the directors of the PTC, would be made available, so that in essence, it's sort of like a form of trust register, but the trust itself is not.
Exactly. Yeah, it's sort of an indirect one, isn't it?
Yeah.
Yeah. Okay. I've raised the issue of the connected trust and its little cousin there, the connected company, and I want to mention it because obviously you can have overseas structures, foreign structures that have connections into the European Union or the UK, either through land or having a tax liability scope, or having sort of regulated relationships with the regulated parties in those jurisdictions. It's important for everyone to note that that can draw you into a register within the European Union or the UK if you have those connections. So the classic would be an example of a Jersey trust that owns land in the UK or owns land in the European Union. That would then force that Jersey trust to then have to be registered. And within the European Union, it's a bit difficult because they have a qualified public access. But they have said that they think that investigative journalists who are looking into money laundering offences, etc., can have access to some of this. So there's a bit of movement in this as well, because obviously the UK has the connected trust register. The European Union has connected trust registers. But insofar as companies are concerned, the European Union have got draft legislation that foreign companies that have connections into the European Union would then have to be registrable going forward. The UK hasn't gone that far, except for something I'll say later on about land. But what I'm trying to get at here is that you can indirectly get involved in these public registers within the European Union, the UK, if you have sufficient attachments. So if you're a Singapore trustee or a Hong Kong trustee, be well aware if you're attaching into the European Union, UK, you can draw yourself into the registrable format. Last bit on this was just the FATF position. Generally, FATF don't take up public registration as their core approach to this. They have what they call a sort of multi-pronged approach to how jurisdictions can adopt their AML when it comes to things like beneficial ownership of companies. However, as we are sitting today, the FATF plenary is up and running, and they're going to be reporting on Friday. It's a shame we're not doing this next week, because I suspect, given the problems in Ukraine, that the FATF may well find it that the review that they conducted last year, the consultation, they'll suddenly find a way in which they'll bring public registers as maybe not mandatory, but best practice going forward, and it could affect your FATF rating going forward. I don't know, Aki, Nancy, you have any views on this? Because up until now, the global standard was, this is for law enforcement. This is not really for members of the public to just troll information on a discretionary basis. So any issues, any thoughts on the FATF position and what we're likely to see? Aki?
So I think that the EU and FATF have a really interesting dynamic in the last few years, actually. And there's a sort of a push and pull between them. I think the EU is operating certainly post 2016 as a kind of a global leader in a lot of legislative developments. And setting a benchmark on which in some areas FATF does catch up, sometimes and alongside the OECD as well. So sometimes it's the reverse. So I wouldn't be surprised if the FATF does get inspired to a degree by what's going on within the EU.
Yeah. Any final thoughts, Nancy, on this?
Yeah, no, I totally agree. And I think, I think it's a really positive thing, actually, the fact that they try to streamline the definition for beneficial ownership. And actually in Jersey, our ML law, they refer to the FATCA position when it comes to beneficial ownership identification. So I think from our perspective, it's quite a positive thing that they're so active in the space.
Right. Okay. Well, we'll see. It will be, they should have their recommendations by Friday. That's their published date for the plenary. So we'll see if they then move to put beneficial ownership as a public right rather than as a law enforcement private right going forward. And obviously that bears upon the amount of information that's available on family office ownership, for instance. Now, another topic, which is the opaque offshore structures. Now, this is subsumed within the mandatory disclosure rules, which the OECD took the lead on some years back now. 2018, I think, was the date that they published this stuff. Now, let's ask, Nancy, from your perspective, how does this opaque offshore structure disclosure rule work in practice? So we've got a trust here. We've got the trust sitting on top of a family office. The trust has got beneficiaries. Let's assume that these beneficiaries are named in a deed, so they're not a class. We've got a settlor and we've got power holder or a protector. So these are the bona fide beneficial owners or controlling persons. So what is the opaque offshore structure provisions looking at if we've already identified the people that are actually going to be the beneficial owners of this? How does it work? What is it trying to get at?
Yeah, so we've got a draft law in place, although it hasn't come into effect yet. And there's sort of two prongs to this. We've got the Crs avoidance element. So where you've got a structure that has the intent or the effect, not the intention, but the effect of avoiding CRS. That will be caught by the new law. And the second prong is the opaque offshore structure. So in essence, if there are arrangements in place which hide or which has the effect of not revealing the true beneficial owners of the structure, then there's the obligation on certain people who are involved in the structure, for example, advisors and promoters, people who design these structures, to report the structure and the effect of it to the controller of taxes in Jersey.
So could that be where you have a settlor that's effectively exercising control over the trust, but he actually hasn't got any reserve powers? But it's a working arrangement between everyone that he can basically call the shots. Is that the type of thing?
Yeah, I think that is possible. There hasn't been much commentary being given in relation to the interpretation of the law, and the law, the way it's drafted, is very, very broad. And so I think so much of this sort of legislation comes down to, what is within the spirit of the law. And so, where you've got a really legitimate structure whereby the settlor purely wants to direct investments, for example, I don't think that is really the intention. That sort of structure is not intended to be caught by the new law. But sort of in a more classic case where you've got some nominee arrangements, for example, whereby the true identity of the beneficial owners are masked by the use of nominees. That is sort of the classic case, which would be caught by the law. But then it's like one of these. It's very similar to CRS. I think that as the law comes into effect, there'll be more examples which are on the borderline, and we'll need then for some further guidance from the legislature as to how far the law would go. Yeah.
Okay. In terms of crown dependencies, as you mentioned, we've got some draft legislation knocking around. I don't know if this is the last bit that was put together, but is it in effect yet, or have we got a timeline for this to come into effect in the Channel Islands?
No, we don't have a timeline for this yet. Because there was some suggestion when the law was first introduced, the draft law was first introduced, that it should be coming into effect in the summer of 2022, so this year. But so far we haven't heard anything further. And given the rest of things that's going on, it might not come into effect until 2023. But so far we don't have a definitive timeline.
I mean, I would think, given this whole Ukraine thing again, acting as an accelerator. Maybe these go slow approaches maybe won't be, I mean, a lot of this go slow is actually down to COVID and people finding it difficult to roll out. So there's a practical side to this. But I suspect that the Ukraine aspect is going to be pushing on this going forward. We'll see. But certainly from the economic...
Can I mention a point just on the opaque offshore structures?
Yeah, because I was just going to ask you from the British Overseas Territories perspective as well. So I was just going to, just before that, I was going to just ask Nancy a supplemental. How does this work with respect to the economic substance rules, the interaction between an opaque structure and a structure that's actually got bona fide substance? Is there any interaction rules here?
Yeah, there is actually. So in the new law, it does refer to the fact that opaque structures, I can't remember the exact wording off the top of my head, but it does refer to structures whereby, they are deemed to be tax resident in the jurisdiction, but their real economic activity that don't actually take place in that jurisdiction. And so, again, I think, the effect is that they're trying to identify structures whereby they're trying to mask their both beneficial ownership and where the real activities actually take place. Yeah.
So I think the broad approach is that if you've passed the economic substance test, then you're not a passive offshore vehicle, right? But the economic substance doesn't apply to a trust. So you're still stuck with the trust being dealt with as if it were a sort of strict liability. So if you have, this is the lesson for everyone out there, if you've got a trust and you're not reserving sort of sufficient powers and people are de facto exercising control of it, this is going to be a candidate for a disclosure under this opaque offshore structure regime going forward. So you want to actually get everything squared away and have bona fide beneficial owners lined up to avoid getting into this sort of morass going forward. Okay, Aki, from the British Overseas Territories, BVI, Cayman, etc., any likelihood that we'll see mandatory disclosure and opaque offshore structures being introduced, particularly in light of this? I keep hacking on about this stuff about Ukraine, but given that we are in where we are and they look as though a lot of legislation will be pushed through quickly in the UK, particularly on this. Any views on this?
So I think from an OT, from a British Overseas Territories perspective, we certainly with BVI in focus, we haven't really seen any attention yet paid to MDR rules, but again, obviously that is part of the BEPS framework. So maybe in years to come that will materialize, and we'll be discussing that in more detail as we are with the UBO registers. I think just what we are seeing on the MDR rules is there seems to be two models that are out there. There's the FATF style OECD mandated international version of MDR rules, which I think Nancy was just effectively giving us a very good description of in Jersey. And so you, Zach. And then we have the EU version, which is all known as DAC 6. The experience on the EU side seems to be that a lot of the provisions look extremely broad on paper, but often when you try and apply them in practice, they are there to target specific products and specific techniques that are used in industries by tax practitioners and those sorts. So I think what we really need to pay attention to is how is this going to be implemented in practice, and the key for that is looking at the guidance notes that are eventually issued, because they say so much more than the legislation, and you can get completely lost if you just read purely legislation.
One thing that comes up in all of that legislation is the retroactive effect of this, where obviously European Union didn't go for the full retroactive period, which is back to 2014, which is the OECD standard. I think Channel Islands might be adopting that approach of going back as far as 2014. But if we see this being rolled out as a go fast sort of initiative across both British Overseas Territories and then into financial centers, into Asia, Hong Kong and Singapore, then it's important for everyone, practitioners on the call, that they realize that the retroactive effect means that things that you're doing now could potentially be disclosable going forward, not just on mandatory disclosure, but also on opaque structures. So that's part of this modern approach of trying to make things effective back in the past. I mean, 2014, no one had CRS, for instance. So go figure why it should be that far back. So another one, just for everyone watching, another one that could be developed quite quickly in light of what's going on with Ukraine, or it might not. We'll have to see. It might just be something that's rolled out over territories that the UK has at some level of control and not internationally. Okay, so just running down to the final couple of the substance sort of assessment of the family office. Now we're looking at economic substance rules, and this comes from a different angle. This comes from the forum from sort of harmful tax practices and BEPS Action 5. So, Aki, from your perspective, how does this thing work? How does economic substance work for members on the call who are not familiar with the rules and what they're trying to achieve?
So economic substance wasn't really designed, economic substance rules within BEPS weren't really designed with family offices and private wealth management industries in mind. So they kind of cut across the industry in a slightly odd way that often doesn't, you know, when you're trying to explain to clients, they often expect to be caught, and then when you say, oh no, nothing's caught, they say, oh, that's a surprise, as if they're meant to be targeted. And that kind of, I think, cuts back to the stuff you were saying on Ukraine. I mean, broadly speaking, you've got a bunch of relevant activities. So if you fall within the scope of the relevant activities, then you notionally need to put economic substance in place typically in the jurisdiction of domicile of the undertaking involved, whether that's, you know, typically that would be a company. So meaning you need to have, from a BVI perspective, real substance in the BVI. Now, of course, there are differing levels of substance. Some are purely notional. So again, when we're talking about relevant activity of being a pure equity holding entity, in most cases, or many or most cases, it may simply be that having arrangements with a registered agent very similar to what people have at the moment or prior to the economic substance rules would be sufficient. In other cases, it means, for example, if there's anything to do with intellectual property, then it can mean actually having a real center of R&D development in the relevant territory. So it really does depend.
Right.
So just looking at your slide there, so pure equity holding company, what's that? So that's a company that only holds equitable interests and receives dividends and capital returns, essentially. So where a pure equity holding company is quote unquote passively managed, then you're predicting what I'm going to say there, Zach.
Yeah.
Then very limited substance is required. So it's a paper-based style substance, which is, you know, you've got your registered agent and you've got all the company secretarial stuff in place as it should be under regulations. Where you have actively managed companies, then those where there's a high turnover within the company of underlying assets that are being actively managed, then the rules point to a stricter requirement on substance. They're silent on precisely what that is. So there isn't a one size fits all, and you know, it can be from, for example, appointing a director in the jurisdiction to possibly more than that. But again, I think what we're generally seeing in the structures affecting family offices is that the holding companies, when we look at the detail of them, end up being fairly passive, and they tend to be managed by someone else. So they're not necessarily themselves being considered actively managed. So, for example, in the chart here, we have a Singaporean company which is a manager providing the active management in the structure.
Yeah, because I think that's the point, isn't it? So if you've got within the fund company a great deal of activity going on, so the fund company is effectively trading quite heavily in financial assets, and these are dipping in and out, I suppose, of pure equity holding from time to time, the legislation doesn't seem to be that sophisticated to do a day count on when you're equity and when you're not. So let's assume it just switches on and off all the time. If you're actively doing that, then that would mean that you would have to look quite carefully at, are you satisfying the substance requirements? Do you have adequate substance in the BVI, for instance, if we're using that example? I think the warning for everyone watching is this: if you've got a Singapore single family office with a BVI company, what used to be a sort of 13X, I think it's a 13O now, or whatever they renamed it. If it's actively managed, then you need to get this looked at, and you need to, ask people like Aki, for instance, what do they think is the right approach to going along with this? Because the effect is, if you fail the substance test, there's fines, but also there's this rather sneaky sort of spontaneous disclosure of information to the residency of the controlling persons. Presumably that's your beneficiary, settlor, and protectors. So there's a disclosure that you are in some way connected with a failed company, a failed substance company. Is that correct?
That's correct, Zach. Yeah.
Right. Okay. In terms of the peer review process, there's two levels that the Forum on Harmful Tax Practices do that. They do a legal peer review, and then they do effectively a practical implementation peer review. Do we have an idea of the status of that going forward? How are we? I know that we've had, sort of COVID has basically stopped a lot of these things happening, or at least pushed them back. But is it actively being reviewed, the practical implementation of these regulations in BVI, Cayman, etc.?
Well, in terms of the peer review process, I'm not sure when that's scheduled for. No doubt it will happen at some point in the future. What we are generally seeing on the ground is that there is real enforcement of these rules in the BVI. I think there's sometimes a tendency to think of places like the BVI as having lax governance, but actually the opposite is true, and the authorities in the UK overseas territories work incredibly well to enforce these rules, because they want to be in the lead of these regulatory initiatives. So we are seeing real enforcement and investigations and those sorts of things. So I fully agree. It's critically important that all the listeners and stakeholders in family office structures ensure that their structures are compliant, because in principle they can take steps to make them compliant, but it's important to actually do it. Right.
Okay. And it doesn't apply to trusts, right? So there's nothing being said about making it expand economic substance to trusts.
It doesn't apply to trusts. Right. That's right.
Okay.
It doesn't apply to trusts, no.
Okay. Right. On the from the CRS perspective, quite quickly on this, standard reporting of a family office. Basically, the fund company is going to be a managed investment entity that will effectively report the controlling persons. The family trust, as long as it receives some level of income, will also generally be within the investment entity criteria. The unfortunate aspect is, because we habitually put together family offices with a holding company, that holding company tends to be a passive NFE, or a passive non-financial entity, and therefore you end up with double reporting going on structures like this going forward. Some structures will be different where they don't have a holdco, but if you've got the classical one, you've probably got double reporting at the trust level as well as the family, the sort of fund company level, and that tends to be the standard reporting format. There's only two things I'll mention when it comes to CRS and family offices that I want the listeners to be aware of. The first thing is where we have a stacked family office. And the stacked one is where the fund management company holds the fund company. Now, ostensibly, this could give rise to zero reporting. And the reason why is you've got an interaction of two financial institutions, the fund manager and the fund company, and the fund manager doesn't have financial accounts as a matter of CRS law. So that could end up with a non-reporting scenario. However, it does, if it's put together this way, deliberately designing it to avoid the CRS, then you've got an anti-avoidance provision within the CRS that can be triggered by this. If you want to look at this further, if you've got a client with a stack structure, you might want to look at the latest OECD FAQ. I've given you the reference there that will talk about what to do with structures like this. But you can have this stack scenario. And I remember when initially this was being rolled out in Singapore, I think some of the providers were saying that they can find a way to have nil reporting, and there we are. So I think this is what they were trying to get at. That would be an anti-avoidance trigger for the CRS. So that's a stacked family office. An enveloped family office is really where the holding company is sat alongside a whole bunch of the client's trading or family businesses. This is quite prevalent in the market space in Southeast Asia, where a lot of the families are beginning the process of decanting their wealth from business wealth to private, private wealth and private wealth management. But the family office, the holdco, tends to sit alongside or holds effectively the trade codes. That can give rise to a deemed active NFE status of that holdco, which would mean the reporting trail on this structure is affected. It wouldn't be a straight look through reporting from the fund company. So it's important, if you have an enveloped family office, one that's surrounded with trading companies, and the family office is just one of a line, that it could be that your holding company is also an active NFE. There's the particular section of the CRS that will help you if you think you've got an enveloped family office. Okay, now going over to John. Obviously the CRS equivalent in the US is FATCA, and we'll just run through in terms of scope of reporting. If we run the normal Singapore single family office, we're looking at it from a FATCA perspective. We've got interested persons, we've got a US account at the bottom, and then we've got potentially US persons as beneficiaries, settlor, protector. A couple of things I want to just run through is potential CRS reporting mismatch between the US and the sort of OECD standard that's been adopted, and then these reciprocal IGAs and how they've been adopted going forward from the US perspective. So I wonder if you could say a few remarks on how FATCA will apply to a single family office where we have these potential variables with US interests.
Sure, thanks, Zach. There are so many acronyms that we all deal with. Many of them can be confusing. This one is very helpful. So if you're ever dealing with FATCA and you got to get your head around it, start with the acronym because it helps you. Foreign Account Tax Compliance Act. It's bringing Americans into compliance the same way that it works internally in the US. In the US, when you go work for a job or an employer or you have an investment account, a set of data is sent to the IRS to double check you. You're not on the honor system when it gets reported. FATCA is that same concept taken globally. So we're looking at, are there US persons that are going to be treated as account holders or controlling persons? Those tend to align in definitions. There's some slight differences, but they're really the opposite sides of the coin, whether you have an FI or an NFFE. So here, looking at, do we have US person beneficiaries? Do we have a US person settlor? Do we have a US person protector? But right at the start, we're going to look at mismatches. So protectors, not automatically in as controlling persons, typically in the US. It depends on what type of powers they hold. That's generally a general power of appointment that creates US estate tax exposure, but it's not an absolute. Whereas under CRS, you have this kind of logical, illogical conclusion. Protectors are caught under ultimate effective control, regardless of whether they have any effective control.
Yeah.
So full stop protectors in under CRS, not necessarily under FATCA. Similarly with settlors, the US has a grantor regime when it comes to describing the person who's responsible from a tax perspective at the top of a trust. But the IGAs were a compromise. The IGAs, unlike the Treasury regulations, don't make the foreign institutions learn the grantor trust rules. They use the word settlor, the person who settled the assets in. This can create a mismatch internally in the US, meaning someone can settle a trust but not be treated as the grantor. They probably shouldn't be reported because they don't have any tax liabilities, but they will be still under FATCA if it's under an IGA. But then under CRS, not concerned at all about who's tax responsible. It's just the settlor, full stop.
Right.
So there are a little bit of mismatch there. And then the reciprocal IGA is just the lip service that the US pays to its non-participation in CRS. So they did not sign up to the common reporting standard, but they will loudly tell everyone that's because every IGA can be reciprocal if a country wants it to be. Very few, if any, are, and the data that is reciprocated is not one-for-one data to what's being sent to the US.
Right, right, okay. Now, I'm looking at it from US perspective of corporate transparency regulations. So is this going to be public, and when can we expect the US sort of corporate registers to get going?
Yeah, not currently envisioned to be public. That's not to say there may not be pressure to do that in the future, but right now, nothing that's been proposed or implemented calls for a public register. We're in the early stages. There are expected to be 3 rounds of regulatory guidance or rule drafts released. Only one of those 3 have been released, slightly on, maybe a little behind schedule. So the current thought is that that's intended to go live at the beginning of 2023, but with the lack of development in those 3 rounds of rule releases, I think it's quite likely that we'll miss that deadline. It'll be further into 2023 or 2024 or beyond before we actually get that.
You don't think the sort of what Biden said today, like going after the oligarchs, etc., you don't think that will be a push to get some of this stuff through?
I don't think so. I believe that from a request and investigatory perspective, that data can be had already. So
Yeah.
the government wouldn't be relying upon this necessarily. We're
Right.
talking more middle to low hanging fruit, not top dogs that this is going to suss out
Yeah.
and perhaps protect the US's reputation, which is not really under huge stress at this moment. The latest Paradise Papers release showed that there wasn't a huge amount of anti-South Dakota sentiment. It kind of got lost in the news cycle amongst other
Right.
mentions.
Right. And then US real estate. So we got the family office getting involved in holding real estate. What's the reporting data trail from that?
Yeah, this is a big point of contention in the US recently. It follows on, I guess conceptually, you can say it follows on from the FIRPTA regime, Foreign Investment in Real Property Tax Act. This is the capital gains equivalent that the US kind of reinstituted for non-US persons back in the late 80s, early 90s. So there's been a big emphasis in sussing out foreign ownership of US real estate. So over the course of the last 3 to 5 years, there are kind of little incremental changes in the types of forms that have to be filed to the IRS to disclose foreign ownership of companies that are typically used to hold real estate.
Yeah.
And also, the ownership of the real estate in those FIRPTA transactions. There's more press to disclose certain identifying information about the foreign owners that are involved in those transactions. It's quite ironic. The US is developing in a way that's the opposite of the rest of the world. The rest of the world seems to be implementing CRS, going hard after bankable and some private equity style illiquid assets, but not real estate. And so outside the US, under the CRS regime, real estate seems to be a kind of a privacy regime. Stick money into real estate, it isn't necessarily going to be disclosed as part of CRS.
Yeah.
US is heading in the opposite direction. Not a lot of urgency to get bankable assets and other financial instruments disclosed in the US, primarily life insurance. But at the same time, they're making a big push to make sure that no one is parking foreign assets into US real estate without disclosures being made in that regard. So it's
Right.
interesting to see the two regimes that were kind of gave birth to one another heading in separate directions.
Yeah, yeah, agreed. It's ironic also because I think what we're seeing from the UK perspective is this registration of overseas entities had been languishing around. This is the one that targets overseas companies holding UK land. That's now being fast-tracked as a result of Ukraine. Scope of disclosure is that if you have a foreign company like a BVI holding a UK land, and it can be retroactive back 20 years in terms of the purchase dates, that company will have to register as if it were a UK company, and the beneficial ownership register would be publicly available in the usual way. That implementation is looking as though it wants to be March of this year. And this is something I said been languishing around for years without any sort of parliamentary time being made available to get this through. So we're seeing it in the context of maybe not full-fledged beneficial ownership registers of land, but we're seeing it if it's attached to a company or attached to a trust, then you're getting to see it sort of manifest that way. Okay. Now, I kept this in the slides. I won't go through it. This is for when we send around the slides. These are just a summary of all the various initiatives and who they impact and where the data goes and who can see it. Finally, going on to the wealth planning implications of all of this stuff that we've been talking about. And I'd just want to invite Steve and Andrew to have a canter through of the industry implications, particularly industry awareness, your wealth planners, your relationship managers, and everybody involved in the private wealth industry, client awareness of all of this. What's the best practice guidance going forward? And I'd emphasize that what we're talking about here are families that are fully tax and regulatory compliant. If they're not compliant, then this is a completely different discussion for them, and we're probably not interested to help them in any event. So this is really bona fide families who are fully compliant. What's the best practice guidance for them going forward? And then how is this going to shape for the entire industry going forward, given that we've got so many legacy structures spread all over the world and having all of these initiatives hitting at what would appear to be different speeds going forward. So Steve, I'd invite you just to give us your remarks on this.
Sure. Actually, Andrew, do you want to kick off and then I'll add?
Okay. Thanks, Zach. So I guess the key things are, from an industry perspective, it's very important for wealth planners, RMs, etc., for us to make sure that we're very close to the topic itself and make sure that we're properly educated along there. I think generally, as far as the our conversations are probably going at the moment, we're probably not going into a huge amount of detail as an industry. We're obviously being compliant and making sure that everything is properly being filed when we're looking after our structures. But when we're having those discussions with clients at an early stage, as well as an ongoing basis, I think it's very important that we're probably more proactive and looking into the future when we're having those discussions about how things are likely to change in the future, and having those conversations up front is very important. Obviously, I think for a client perspective, and we're talking about, as you've discussed, compliance structures, compliant clients, they're generally, they're interested. They want to know, how their families, how their structures are going to be affected. And obviously, it's part of our role as service providers, as wealth planners, etc., to make sure that we give them the right level of information. When it comes down to best practice, I guess we're looking at going forward, potentially entering into this position where we have a two-speed arrangement, because there's lack of a global standard at the moment. So different jurisdictions will have implement things in different ways, and therefore how is that going to affect choice of jurisdictions for clients? I think that's going to be interesting to see how that pans out. Steve, is there anything you want to add on at the moment?
Sure. I think you referred to, or there's been several references obviously to clients, and I think if I think back in the last 10, 15 longer years, and the journey that clients have been through, and the industry has been through, and therefore clients have been through, first of all, being compliant isn't a choice anymore. I mean, it's inevitable. It's a question of how to be compliant whilst trying to preserve your wealth and get as much privacy as one can legitimately get. I mean, you think of things like source of funds, KYC, all these things have evolved over the years. And it's normal. And other things that are normal now are things like CRS and FATCA we talked about. Clients get it, they know it, they accept it. And they're also prepared to provide their own information, which is inherently confidential, to reputable tax authorities and regulators. So this has been happening, right? And it is happening. So that evolution, I think, we kind of take it for granted sometimes, but when you think back, the world has changed significantly. But I think looking forward, and I think, Zach, you alluded to it, and Andrew as well, looking forward, I think the big, the next couple of years in particular, the big point will be on public registries. It's one thing to provide your information to regulators or regulated trustees like us and others. That's one thing. But to be in the public domain, is clearly another matter, which seems to go against other data privacy, GDPR, and other things like that, right?
Yeah.
So the next few years will be very interesting on that, and you know, we talked about the Crown dependencies and elsewhere, where there isn't a final view yet. So, you know, as to what they will do. So that brings me to I think the jurisdictional point Andrew was making around what will happen here. I think families and their advisors will consider different jurisdictions based on public or non-public registries. And I think the only other comment I'll make is, I think we sometimes forget in our industry, I mean, we're dealing with all these things, and as our clients are and their advisors, but I think what often gets forgotten is how important we are. This is not necessarily a bad thing, if I could put it that way. In a way, we are the checks and balances for the world in reducing money laundering and tax evasion, etc., through the type of things we're talking about. I think that sometimes gets lost with even in our industry and with some clients, and I find myself having to remind folks of the good that we do in that context as well.
Yeah. Aki, what do you make of the prospect of BVI companies becoming onshore companies in terms of their tax residency status? So they start to migrate off into a mid-shore context and start taking on a rather hybrid approach. Do you think that that's going to be the future?
Well, it's certainly a possibility, and there is a framework within the economic substance rules that allows for that. So I think it's a really interesting development, actually. And where a BVI company is tax resident in another jurisdiction and can evidence that, then it essentially falls outside of scope of the economic substance rules in the BVI. So I think, you know, we're generally seeing that develop.
Yeah.
Obviously, it requires close cooperation between the onshore/midshore jurisdiction and the BVI or the other relevant OTs.
Yeah.
So yes, I think that's certainly a possibility.
Right. Nancy and John, anything from you on how this is all going to shape? Any final comments on this particular point, which is wrapping up the sort of the legalistic bits of this talk?
I would just add that I think, you know, there's been a shift amongst financial institutions, both trustees and banks, the end of banking secrecy and an emphasis on multi-jurisdictional regulatory compliance. In some ways, private attorneys are the last vestige of privacy. Attorney-client privilege still exists in many jurisdictions. We can be a relief to both clients and to providers to have conversations that might not be appropriate for other. And then also, I just think that the privacy stuff is coming regardless. So folks that remain buried in their head in the sand are missing out on the best opportunities. When we look back at the US voluntary disclosure regime, those Americans who came forward in 2009, 2010, 2011 did far better economically and criminal penalty wise than those that are just now getting their ducks in a row and coming forward. Same globally, when you look at the banking industry, banks that went through deferred prosecution agreements and resolved their troubles back in the early 2010s are doing far better and got a jump start on cleaning out their book of business. So privacy is coming, and it's not about avoiding it. It's about finding the most efficient structuring that accommodates it.
Right. Okay, right. So we'll move on to the final segment, which is all around cybersecurity in the context of the single family office. And I think this is very important because we're seeing family offices being developed on the fly, sort of DIY approach to how families are managing the sort of infrastructure, the physical infrastructure aspects of the family office. And I wanted to have a chat around the cybersecurity because this sits quite squarely with some of what's happening on the transparency initiative that we've been talking about earlier. So some of the areas that we discussed: level of risk in terms of the cybersecurity risk going forward, the types of risk that families are likely to experience, specific family office risk that we can mention, and then what's the best mitigating strategies that families can adopt, given that in many cases they're completely without any level of guidance on how to handle these things. So if I just invite Paul, if you can just give us some sort of high level stuff on how the risk is shaping and what's going on in the marketplace, because I think for all of us on this call and for the viewers and everybody else, I think we have no real idea at all about how this thing looks.
Yeah, thanks, Zach, and a real pleasure to be here. And I'll try and keep this one high level, as you mentioned, because let's face it, beneficial ownership, opaque offshore structures went right over my head, I'm afraid. So I'll try not to go over everybody's head on this call from a technical point of view. But yeah, look, thanks for this. Thanks for inviting me along here today. Just a little bit quickly about me. I'm former Hong Kong police, 22 years running cybercrime investigations, dealing with frauds, cyber, etc. And also a number of years with JP Morgan running their global cyber investigation team. So I've got a long history of working in this space. But what we're seeing, right, so I get asked this at the beginning of every year, what are the risks, what are the levels of risks and the types of risks that we are seeing and that we're forecasting for the year ahead? And I can tell you right now, one of the key points I've been making at a lot of these discussions is that the attackers are shifting their focus towards high wealth individuals.
Right.
Because they're after the money, right? And they're recognizing that what's happening is that, you know, firms are getting more savvy, bigger firms, I mean, are getting more savvy, they're building stronger defenses. So of course they're looking for, I hate to say it, but weaker targets that still can, they can monetize,
right,
but don't have the security levels commensurate with those bigger firms. So let me talk about the four main risks or the four main threats that we're seeing currently. So the big one, no surprise to everybody, probably is ransomware. And I'll tell you what, I'll circle back to that. Although it's the biggest one, I'll come back to that at the end. But the other three are really email compromise. So email compromise continues to be rampant. We saw this peak at around 2017 and then dip considerably. But this year, towards the end of last year and earlier this year, it's really on the rise again. And what this facilitates is a number of things. If somebody breaks into your email, it allows them to impersonate you, to commit fraud in your name, and hence the reputational damage. It may not be, you know, directly lost to you, but it's your connections, your clients, your contacts that are getting hit in your name with investment opportunities or with, you know, with other kinds of scams. And that's definitely on the rise. So protecting the email is critical. And you also think about the wealth of personal data that you have in your inboxes, in your mailboxes, etc. If some threat actor or some bad actor gets into those mailboxes, the damage is immense. Right. And they are starting to monetize this through extortion, through blackmailing you and essentially, you know, threatening you with exposure unless you pay up a certain amount, usually in crypto. So the email compromise, huge. So that's the second one. The third one is cyber extortion and scams. I touched on that sort of briefly with the email compromise, but it's broader than that. We're seeing high wealth individuals constantly targeted, family offices, etc., with various types of scams, and they're clever. It's getting harder and harder to detect real scams from, real emails from these scams. I mean, I just had an email right now, just as I was talking to you guys, from a connection in Hong Kong who was just seeing an email from the Hong Kong government off the back of the latest outbreak in Hong Kong, and is spoofing very, very effectively the Hong Kong government with email, and it's all a big scam, and it takes them to a malicious site, etc. But because of the fear currently prevalent in Hong Kong, people are clicking on these links without really stopping to think because they're panicking over what the situation is. So the criminals are very good about leveraging ongoing political situations, be it elections, be it Ukraine situation, be it the COVID situation. It's getting harder and harder to detect. So you need robust controls in place to protect yourselves from yourself, if you know what I mean. We're all human. We can all click on these things. We can all get pulled into these things. So the best protection is to have some kind of technical controls that can identify the scams versus the real ones, and hopefully protect you before you get hit. So that's the third one we're seeing, is scam. Oh, sorry, we're also seeing a lot of romance scams as well. I hate to say it, but you know, mostly male, I'm afraid, but who gets pulled into how do we say, dalliances with female connections online, and it turns out that they're actually recording everything that goes on and then sorting afterwards. And this is because it's embarrassing. You don't hear much about it in the public eye, but I get a considerable number of individuals coming to me, very senior often individuals coming to me, that are being extorted this way. Or it may even be something that's not real actually, but they're very convincing, and they are, you know, they're extorting or trying to threaten you with extortion based on you know, stuff that's not exactly made up, but enhanced, shall we say. So that's the third one. And the fourth one is crypto. So obviously a hot topic at the moment, and
Yeah.
we're seeing, and the Crims are looking for, so when they're doing their hacks, when they're doing their scans, they are looking for wallets or any kind of information about crypto on the target systems. And they're getting very good. And a lot of this malware is now just specifically looking for wallets or any information about transactions in the crypto world. Again, once crypto's been moved, it's hard to reel that back. We do a lot of investigations around that.
Yeah. So listening to you, the specific risks, I suppose, is the fact that your average family office, the family be wandering around with an iPhone that has both their family office traffic as well as their personal traffic running on probably the same emails, or at least everything's being dealt with on one device in a sort of semi-casual way, because this is nothing more than a personal investment company with whistles. So is that going to be the problem, is the fact that it's all very casual and you're just acting as though it's a sort of online account?
Very much so, Jack. And we're seeing that time and again. And the mixing of personal and the business side is quite prevalent, and that is a recipe for disaster, I'm afraid. And also, we've seen it. Given another example, we had a major incident that we had to investigate from a very senior board member of a bank. I'm not going to name them for obvious reasons, but that individual served on multiple boards and yet was just using one computer for convenience to access information from each of those boards from different institutions. And hence, who looks after the security? Because Bank A could not do it, because then they would possibly see information about organization B. On the board for. So if anybody out there does serve on multiple boards, this is a big issue. Who guides you on the security? Who guides and strengthens and also segments? Should you be carrying individual devices? It's troublesome, right? Nobody wants to carry multiple devices, but there are ways of segmenting, and there are ways of if you like, firewalling off the personal and the work. And again, we do provide that kind of guidance, but we see it time and again that individuals don't do that just for convenience. And definitely.
In terms of these beneficial ownership registers and the information that they're likely to give out in terms of beneficiaries of trusts and settlors of trusts and shareholders, etc. Obviously, for high net worth individuals, some of them will be very prominent. They'll be featured in Forbes and Fortune magazine, etc., and the rich list. But actually, it's the second and third generation that don't generally surface. You don't really see them much in public. They're quite wealthy in their own right, but they're overshadowed by the head of the family, who's quite public. Do you reckon that what's going on is that as the sort of criminal elements focus to looking at high net worth, that it's really the second gen, etc., that are going to be the targets of their attention, because they're probably not going to be in any way protected?
Very good point. Very good point. Because the criminals, organized crime is, as the name suggests, becoming very organized. They do their research. Again, if the money's drying up from sort of more traditional targets, the big firms, then they are going to do their research on how, and of course they're going to find out who the relatives are, the younger ones, etc. They'll go after them, and they'll start scanning. They'll start to do all the mapping out of everything, looking for ways to target. And as I mentioned, the first threat I mentioned, ransomware, well, that's now coming with data exfiltration. So what the bad guys are doing now, if they'll try and encrypt. So ransomware means you basically lock up the data so it becomes inaccessible until you pay to get a key to unlock the data, right? If that doesn't work and you're not paying because you got backups, say, for example, what they're doing before they lock up the data, they're actually stealing data. They're taking away, your records, your spreadsheet, your databases, whatever it might be. And then they'll threaten to expose it unless you pay them. So it's a double of extortion.
I can imagine, I can imagine clients from politically sensitive jurisdictions. That's a nightmare scenario for them to have the prospect of that data leak going on. Okay, in terms of, I don't know if Jez wants to contribute, in terms of the risk mitigation strategy. So what should we be doing? What's the advice that we should be giving, given that actually in the market space, I haven't seen any, other than a few multifamily offices that are actually taking this seriously with clients. So what's the sort of best advice for clients going forward? Do they have a private server like Hillary Clinton, for instance, or how do they do this?
Thanks, Zach. Look, family offices are not immune from a cyber attack. Like any individual, a family office can be attacked, and you need to take steps to protect against that. It's of course going to be an increasing target given the significant value of wealth of assets under management, right?
Yeah.
It makes it worthwhile. Why target 50 individuals when you can go for your whale? Okay, that's the fact of life in terms of the people who are profiling individuals at the moment.
Right.
So if you look then in terms of, you know, the type of attacks, you get attacks from the usual cyber criminals, but also, of course, as we've seen in Paradise Papers and Panama Papers, you've got journalists, activists, investigators, and tax authorities, all wanting to know the confidential banking arrangements of the wealthy, right? And that it's not just a privacy issue, it's a brand issue. It's undermining, it's attempts to undermine the personal brand of individuals who have wealth. And that's a key concern. So they really do need to look carefully at how to protect, right?
Yes.
So if you look at social media as an example, lifestyle cues in social media are often used by profilers for attacks.
Right.
So they look at what you're doing on Facebook and a number of other social media sites and use that to basically create a way to facilitate a scam.
Right.
Okay. The problem is a number of individuals, you mentioned the second and third generations, but of course, you know, you've got the elder statesmen as public statements of overt philanthropy. That adds to risk because it doesn't take much to work out how many children somebody's got. Generally, people will know because they've gone to events together and so forth. And cyber thieves, of course, profile them as potential victims. One of the things which I think is often forgotten, you've got individual risk, you will have family office risk. But the other risk, which I think is often overlooked, is the professional advisor risk. And the more complicated your group of advisors are, and particularly with the work from home regime that we've seen over the period of the COVID pandemic, I think it's vital that people realize that you're only as good as the weakest link in that chain. Because you could take all the protections you like in terms of an individual, but then find that you've actually not protected at all because one of your advisors has lost his phone. And all the data's on there, right? So, of course, the key thing here is high net worth individuals have the ability to pay. Again, there's no point in actually blackmailing, extorting money from somebody who hasn't got the ability to pay. And one of the things we've seen is over a period of time is luxury locations being targeted for wireless spoofing. So hackers are targeting luxury hotels as an example, 5-star hotel lobbies and airport lounges using public or open wireless networks. And this is the key for me in terms of today, for me giving pointers for you guys, is to deal with that issue. Because securing your Wi-Fi, home or office, it doesn't matter on one level, because, you know, a lot of these family offices are very unsophisticated systems in terms of their operation and indeed their security, physical security of their offices. So first of all, you need to make sure that the default name of your home Wi-Fi doesn't effectively demonstrate which brand of router you're using. It's like advertising, come and get me. I've got, you know, this has got a fault we all know, and a good hacker can get through that. And secondly, you've got to make sure you've got a strong password and not your grandmother's surname, you know, maiden name and all that type of stuff. Proper passwords.
So I think, Jez, it's a question of two things, because if we're looking from the sort of family officer's perspective, they need to have protocols that actually tell them this is how you handle this risk. So they need to have something that they can follow. And then on the second side, I think, is from what you're saying, we actually need to have some solution, either software or hardware, to try and keep these things under control. So it's protocols, what you need to do, and then separately hardware and effective, you know, protective software. That's basically what's missing at the moment, where they're running it just like they're running their own private affairs.
Of course, but if you actually put levels of protection in, for an example, if you enable network encryption, okay, most routers will allow you to do that, okay, for the Wi-Fi. You disable remote access, right? you create a separate guest Wi-Fi.
Right.
Why on earth would you share the Wi-Fi password? Because you're effectively sharing with an individual, any bad actor.
Yeah.
So a bad actor could come into the office, have a chat and say, oh, by the way, do you have your password? And you give it to them. And all their intention was to get the password from that meeting.
Yeah, yeah.
And then they use it to commit all sorts of wrongdoings, right?
Right. Okay.
And simple things like turning off the Wi-Fi when you're not using it, right? And making sure the router's software is up to date. These are all examples, but the main one, just for you and everyone else on this call, if you're not familiar with it, use a virtual personal network, VPN, to access your network. People keep on going to coffee shops and logging on, and people don't realize that that data can be compromised in short order. And that's why, as I say, the hotel lobbies and the airport lounges are being targeted by high-end criminals. No, you want to be in the first-class lounge at Singapore Airlines, right? And and then see who's sitting around, and maybe they know who's sitting around.
Yeah.
So those are key issues for me in terms of dealing with practical things connected with Wi-Fi.
Very good. Okay, I think we leave it there.
Could I just add one point? Just one point.
Sure, please go ahead.
On that one, it's most family offices, they'll have an IT provider who helps them often set up, etc. Unfortunately, these providers, security is a very different skill set to IT infrastructure, etc. Just bear that in mind when you have them, because but this is a huge topic. We could go on,
I mean, just looking at Steve, I think from you guys are busy in Singapore creating family offices. I mean, this sounds like a good team up that you guys could have in terms of the physical infrastructure for these clients, and not just the legal infrastructure from when they're putting these things together. Might well be a decent sort of synergy there. Right, a couple of questions. We'll just deal with them quite quickly before we log off. How to create economic substance for pure equity companies such as personal investment company in the BVI? It's the first question. So Aki, how to create economic substance? I think the answer you've given is it's variable. It's not one size fits all. But how to answer that one?
Excuse me. Absolutely. So basically, it very much isn't one size fits all. And if we and the sort of the anecdotal evidence is, as far as family offices go, is that excuse me, BVI companies tend to hold mixed bag investments. So they don't tend to fall into the pure equity holding entity definition. Again, the reason that there is this focus on equities as opposed to other assets is because the economic substance regime is trying to capture the institutional use of companies like BVI companies. So that rather than that, having a broader portfolio of underlying investments, which is what we typically see in family offices, means that you just fall entirely outside of scope of that particular rule. And then it's really working with your providers, with your trust companies, with your legal counsel as well, to understand what is the correct approach. And the trust companies will often want to liaise with legal counsel for advice as to what is the correct amount. Legal counsel, the way that we get there is by looking at all the guidance notes across jurisdictions to see what is the benchmark for this particular business model, and then we can advise on that.
Right. Okay. The second question deals with the stack. Would not the fund management company have its own equity and debt holders? No. So a managing, not a managed entity. So a managing entity doesn't have financial accounts. Okay. So you're only looking at what would be a Part B entity. That's the one that would have financial accounts. So the managed entity is the one with financial accounts. The managing entity, the fund management company, does not have relevant financial accounts unless it's being used for anti-avoidance purposes. And the last one is, does mobile phones also get hacked? How can we prevent it? How quickly can we answer that one, Jez?
Let me answer.
Both of you have a fight about answering that one.
Yeah. Jez, let me answer that, Jez, because it's quite technical. But the answer is you can and you can't. So the bad guys are looking to tempt you into getting malicious apps on your phone. So just try and avoid clicking on links. Just only go to the authorized app stores to get the apps. Don't click on the update emails or messages to update apps, because they're generally malicious. But unfortunately, at a government level, long story, they can inject it at the telecom level. So let's not go there, right? But look, I know with short time, and a few people have been connecting with me on LinkedIn. I noticed that, and please do, because I'm happy to answer these questions. The more that you do that.
Brilliant. Okay, then, guys. Well, look, I think that's it. We're at an hour and a half. I'd just like to thank everyone that's contributed. Andrew, thanks very much for coming on board. John, as always, thank you. Aki, thanks for tuning in from all the way from Cyprus. And of course, Nancy, thanks for waking up so early. And Steve, both of which are in Jersey. And for Paul in Hong Kong, thank you, very insightful. And Jez in Singapore, thanks very much. And for everybody that's viewed it and stuck around, thank you for spending time on this webinar. And we'll have more in future on obviously family offices as their topic. Okay, thanks very much. And I think that'll be all today. Thanks.
Thanks, Zach.